So before I release you to go and prepare towards your seminar, we are going to discuss a very short topic. So we are discussing criminal aspects of healthcare, a very short topic before you'll be released to go and prepare for your seminar. And then we meet also tomorrow at our usual time. There's a few things for you to read. They've been highlighted there. Postgrads work criminal aspects of healthcare, legal ethics and ethical issues for health professionals. We shared that document with you. And then the PEL, doctors abusing medical care, face fines and expulsion, reported in the New York Times some time ago. And then the Karakakis, the missing victims of healthcare fraud. Then the Holy, nurse who tested photo of unconscious patients, penis, surrender license, the Washington Post. Of course, there are a lot of literature, but these are just indicative. So the point we would like to note at the very outset is that, yes, the conventional thing is that when something goes wrong in healthcare or clinical setting, is to find out or explore whether there's any civil liability. So can we bring something like a cause of action or a case in negligence, like clinical negligence or medical negligence? Is there a breach of confidentiality? Or is there a breach of contract? Again, quite apart from negligence, breach of confidentiality and a contract, there may also be a professional discipline inquiry. For example, those belonging to the pharmacy council, you may have to face disciplinary before them, or the medical and dental council for physicians and doctors, nurses and midwifery council, and so on and so forth. But there is another distinct area which is not often emphasized much compared to the civil liability. That is the criminal dimensions of healthcare or criminal aspects of healthcare, where an established wrongdoing will attract predetermined punishment. Be it a fine, that is a monetary payment, or imprisonment, where you are incarcerated. Maybe forfeiture and regulatory creation are there. They are some of the consequential orders which, under appropriate legislation, a court may be able to make once it is established that a certain criminal conduct has been indulging in any aspect of a healthcare practice. Now, we see that where we are talking about criminal aspects, the focus in terms of the consequences of the reprehensible conduct or behavior, which is in focus, having been indulged in by the healthcare professional or health institution, is not so much about letting the person pay compensation or imposing professional sanctions, as the case may be. So there are two important propositions which we would like to note at the very foundational level of our discourse. One, not every bad outcome is a crime. So let's get that right. It's not the case that anytime something has gone wrong, anytime there's something amiss in the physician-patient relation with the clinical setting, then we say that the crime has been committed. No, that is oversimplification of the matter. It's not like that. Criminal law is concerned with culpable wrongdoing. Wrongdoing of a certain legal quality. So therefore, the lawyers among you know this too well, that to talk of a criminal offense, we need two critical ingredients. We need what we call the we need the actus reus. Actus reus is the prohibited conduct or the particular act which is not supposed to be done or is supposed to be forbidden. And that alone is not enough. You must have done the prohibited act with a requisite or a certain mental frame or mindset. And we call that mens rea. So mens rea. So that is very important. Of course, you also have what we call like a straight liability offense. So straight liability offense is where when you have engaged in a particular act or particular conduct, that in itself may suffice for you to incur criminal liability without explicit determination as whether you had a certain mens rea, because the mens rea or the mental guilty mind or the guilty state of the mind is actually embedded in the act or is implicit. So you don't have like a separate analysis as is done conventionally for many offenses. So you call that the straight liability like offenses. Of course, typical example would be maybe practicing a particular area of medicine or healthcare without having the license. Where, I mean, that one, it doesn't matter the intentions you had, like the good motives. So you are not licensed as a surgeon. You go and open somebody's up, the person dies or something happens. It doesn't matter that you wanted to do your best to save the person. The law says that you should be licensed. Just like driving, you must be licensed before you can drive. It doesn't matter that somebody was in coma and there was no ambulance around. There was a car, how to drive, but you don't have license. So you have to drive the person to the nearest hospital. No, you don't have license. So that is strict. So it doesn't matter, straight liability. The other proposition is that healthcare is heavily regulated. So criminal liability often arises through statutory offenses, maybe like fake medications or counterfeit medicine, unlawful sale or manufacture, as the case may be, or maybe national health insurance related fraud, narcotics control under the Public Health Act, or even data protection offenses, among others. For example, you saw how I mentioned a publication. I'm sure that some of you were shocked when you heard it. It sounds awful. Holy P. Ness, who tested photo of unconscious patients' penis surrounding license. So that's it, the kind of thing. So by the end of this lecture, it is expected that you'll be able to, I'm teaching. It is expected that you'll be able to draw distinction between civil negligence on one hand, from let's say criminal negligence and other health-related crimes, and also become familiar with some of the criminal offences under our various Ghanaian legislation, which relates to healthcare practice and institution. We only give some examples, but they are not exhaustive. Once you have the the analytical compass, the framework, you'll be able to identify many other examples. And of course, health fraud, we should be able to analyze the health fraud. And health fraud here has a number of aspects: economic and patient harm problem. Then you should also be able to explain how privacy violation can attract criminal consequences, just like the lady who took somebody's Japanese picture and then circulated. Was published in the New Times or the Washington Post. And once you understand this, when you have scenarios, fact scenarios, quite apart from the civil law aspects, you should now be in a position to also inquire, be able to interrogate whether there are potential criminal aspects that arise from certain common clinical scenarios that you may be given. So that is important. And then we are also interested in finding out how criminal liability attaches in healthcare. In other words, in healthcare practice, medical practice, how can we say that a criminal liability exists? Next semester, when we are discussing medical negligence as a whole course on its own, you notice that we talk about clinical or medical negligence in several sense. You'll be told there should be existence of duty of care, breach of that duty of care, there should be consequent or resultant injury, and so on. That is pretty straightforward. But in as far as criminal liability is concerned, a number of possibilities. One thing we have to note is that, yes, we have the general criminal legislation, what you call the Criminal Offences Act 1929, as variously amended, which is like the general criminal framework. And then when you go there, provisions on causing unlawful harm, and also provisions on abortions, the exceptions which are created for healthcare professionals or doctors, and where a practitioner is not able to bring his opinion of the relevant exceptions and like that, then there is a problem. So we have that the general criminal legislation from, as I've mentioned. So that one needs to be noted. Now, if we look at 29, conduct or behaviors which arise within healthcare or clinical setting that may give rise to criminal liability or responsibility is assessed using the ordinary principles of criminal responsibility. So we don't make reference to specialized regulatory regimes. If I say we don't make reference to special regulatory regimes, what do I mean? For example, we have the Data Protection Act, which you are very much aware of. We have the Public Health Act, which you are very much aware of. We have HEFRA, like the registration of facilities from where health practice is supposed to take place. So these are specialized regimes. And of course, apart from that, you did I'm sure you've discussed the Anatomy Act with Dr. Divine in some of the models. And that is also another specialized regime. Yes, they are all, they create criminal offenses, but that is done through a dedicated legislation. So that one is there. But what we are currently concerned with is if you look at the general law on crime, Criminal Offences Act, what does it say or how is it relevant in talking about healthcare practice? So that is the point we are trying to make now. So, for example, under Act 29, criminal liability arises where conduct or omission satisfies the elements of offenses recognized under Act 29. And I've indicated that, generally speaking, every offense, as a general rule, we should be able to establish the two critical ingredients or elements: the prohibited act or omission, as the case may be, known as the actus reus, and then the required or the requisite mental state for that particular prohibited act or omission to become a crime. And that one is known as the mens rea. Of course, I have noted not too long ago that an exception to the rule that you need the two ingredients or the coincidence of the two ingredients for a crime to be committed is where you're dealing with the strict liability offenses, in which case only the act is needed to be established. As a person engaged in the criminalized act, prohibited act, if the answer is the affirmative, then the crime has been committed, and there's no need for us to do a separate analysis or ascertainment as whether you had any particular mens rea, because the mens rea or the requisite mental element is not simply created, is embedded in the act, as it were. So we have offenses against the person, such as assault. We are just going to use a very broad brush approach because, for obvious reasons, we don't have the luxury of time. So this is just like a small topic within the model. But if you have the interest, you can take the legislation and look at the specifics. So we have the offense against the person, such as causing harm, causing harm. Of course, under the law, if cause harm to another person, that is prohibited. But exceptions are provided for legitimate medical practice. So where you have to, for example, inflict a pain on someone by injection or some other infusion or things like that, that is permissible exception. So there's a lawful justification. The lawful justification is that you are licensed to practice medicine or the particular healthcare, and what you're doing is legitimate activity. You're not doing it just for anything, but just as part of the care delivery, as it were. As you know, there are a lot of medical procedures which otherwise who have qualified as causing harm. Take something like the how do you call it, colonoscopy or something? Is that how you say it? Good. Good. Uh, can you describe it briefly, like in layman language, so that those who are not healthcare professionals in the class will understand?
Okay, that's Joyce. Good evening, everyone. So in the procedure, tube is passed through the rectum to look at, to visualize the intestines and the GI tract, basically the intestine, and the inflation of air into the backside to be able to visualize properly. It's a very uncomfortable procedure, especially if you don't let out the air as it is done, and it can be very painful as well because of accumulation of gas. Basically, so.
Right. And then what about endoscopy?
Endoscopy is similar, but that comes from the top, so through your mouth, and then you go down through the esophagus to visualize the gastrointestinal tract as well.
So which one is more uncomfortable of the two?
I'm not sure, but I think the colonoscopy will be more uncomfortable because that you push in air.
And can it be done under local anesthesia?
I'm not sure, but you need to be able to let out the air. So usually you're not anesthetized, but then you can.
All right. Thank you. Yeah, of course. We also have a homicide related offense, that is murder or manslaughter, and also manslaughter, murder, intentional killing, and manslaughter, where you have killed someone by unlawful harm, except that you didn't have like the intention to kill the person. So let's look at it. Somebody carries out like a procedure, a surgery, and the patient dies. May not be possible to bring the charges of murder in greater majority of cases, about 99% of cases. But then, depending upon the particular facts scenario, probably manslaughter may be permissible. So let's suppose that you do at the anesthesia. Let's suppose that maybe the anesthetist didn't follow the established procedure. So the person was given a certain dose, which is not accepted by any body of opinion within the medicine and so on. And as a result of that, let's assume that after the procedure, when you try to revive the person or the thing did not wear off and so on. So it'd be difficult for us to say that maybe the person that necessarily intended to kill, but then having violated established protocols, acceptable parameters for doing that. Of course, unlawful harm does not come within the classifications, and death has occurred. So you could be facing manslaughter in appropriate set of facts, as the case may be. And so negligence-based offense, what do you call it, the gross negligence, manslaughter, for example, the conduct departs so gravely from acceptable standard, just like the one I was explaining, and is regarded by criminal law as blameworthy rather than merely careless, as the case may be. We also have offenses. If you look at 29 fraud and dishonest offenses, you may think that, oh, but how is that relevant to healthcare, or how is that relevant to clinical setting? Very much relevant. For example, if we are talking about the forgery and falsification of accounts and things like that. When it comes to medical records, records, you can tamper with it or alter it for some other base motives. Particularly so, either you want to help somebody to secure a certain advantage or any other thing that you can think of. Or even and doctors, you have to be careful with this, especially when it comes to medical for job purposes. That report for job purposes. I think the sense that employers in society places significant faith in what you write. So assuming a person has a particular health condition which is not appropriate, whatever job or career that he is applying, and you just write anything which you let the person pass through, I think you could also get yourself involved criminally, apart from the civil side, which we'll discuss later on. Again, when it comes to investigation, something has happened. The tendency is for people to tamper with evidence, to destroy records, medical records, to destroy it so that the evidence is some sort like a buried. Now, if you did that, and it can be established that certain crucial medical records were destroyed because something had gone wrong, you were trying to just, over your back, destroy the evidence. That in itself can be an offense affecting administration of justice. And you could be in trouble criminally. So let's keep that in mind. So in terms of conceptual characteristics of this general criminal liability that you're talking about, as I have indicated, foundationally, or orthodox or classical criminal law theory is what I'm explaining over and over again, that liability depends upon proof of traditional elements. One, a prohibited act or omission called actus reus. Two, a culpable mental element or mens rea, unless displaced by a statute, which we call the straight liability offenses that I explained. And of course, not necessarily separate, but embedded in all this, what they call causation and harm, where the offense requires it. So where you need to establish a nexus between the particular prohibited act or omission and whatever that the complainant has occurred, the causation becomes important. So, for example, a pharmacist, you didn't pay attention to what the prescribing physician or doctor had written. You just went ahead to just write anything regarding dosage. The prescription may be a very good prescription, but here is the case. Here is the case that the pharmacist, you didn't pay attention and you've written like a wrong dosage or giving wrong direction as to how the medication should be taken. And as you know very well, some medication, following the instructions for taking, is as important as the correctness of that medication, as it were. So that is something that we have to also pay attention to. So the pertinent thing is for us to always be mindful of the distinction between criminal wrongdoing on one hand and then civil negligence or professional error on the other. Of course, the same set of facts can give rise to threats. The same set of facts will give rise to criminal liability if the conditions or the requirements that we have been exploring are, for example, present. And at the same time, some cause of action may be negligence, breach of confidentiality, or breach of contract could also arise from that same set of facts. And at the same time, it can also be framed as a professional disciplinary matter, in which case the relevant regulatory body will have to come in, be it the Medical and Dental Council, Nurses and Midwives Council, Pharmacy Council, Psychology Council, and so on. Let's keep that in mind. And criminal law is not concerned with adverse outcomes necessarily. No. But with conduct that is sufficiently culpable to run in a sanction. Several cases often are concerned with adverse outcome and commit a criminal offense with respect to healthcare practice where nothing verifiable in terms of maybe somebody getting injured or something like that has gone wrong, but you still committed an offense. So let's keep that in mind. Let's look at some regulatory and statutory crimes. So what we just look at is the fact that under the general penal legislation, the general criminal law, what they call the Criminal Offences Act, 19 Act 29, as variously amended, some crimes have been created with respect to healthcare or clinical practice. Now, quite apart from that, we also have what they call like the dedicated or specialized statutory regime, which also govern crime emanating from healthcare or clinical setting. So, if we look at we have the regulatory and statutory crimes. For example, public health protection and risk control. When it comes to public health protection and risk control, we all know the Public Health Act. You have a whole model on the public health, so you know this too well. And if you have paid attention to the legislation, the Act 851, you notice that a lot of crimes have been created by that offense, all aimed at protecting public health and also controlling risk. And here, the emphasis is not so much about fault-based. We rather want to be preventative. And that is why those offenses are there. So, for example, when it comes to manufacture, right, that it becomes an offense if you have not been given a license to manufacture certain health products or drugs or herbal medicinal products or medical devices, cosmetics, or food, things which goes into the human body, the human organism. If you will not be licensed, you will not be given the requisite approvals. And for example, you indulge in manufacturing, importation, distribution, sale, or supply of any of these regulated products, have committed an offense. So here, nothing really has happened in terms of you having caused harm or created any trouble, as it were. But we don't want that even to happen. And that is why it's a gatekeeping law that you can't do any of this unless and until you have been given the requisite authorization or you have the necessary registration. That is why if you discover the best of medicine, malaria or any disease, not being permitted to start to start selling it just because you think that the medicine is good. No. You need to get the necessary approvals. And the Food and Drugs Authority, the Ghana Standards Board, they know that they have their laboratories where they will subject that medicine to the requisite review. In fact, when I think of public health, I become scared for our country. And I only trust in power of protection and deliverance, especially a country where people are so fixated with money and they place money over and above other important values. We need people of high moral integrity, and they are not working just because of money. And I just imagine people need approval or license. And if they don't do proper investigation, verification, and analysis to ensure that whatever is going to be put on the market, it has the requisite level of wholesomeness and it will not become injurious to that is the thing. And just especially so when it comes to the labeling, the labels on products, as whether there is a congruence through consistency between the label on the medicine or the product and the actual active ingredient and whatever else is necessary. Only God knows. And that's why the Food and Drugs Authority should be very serious body. Because if they don't do their work well, they are signing the death warrant for so many people. Because we, the consuming public, we don't have the ability, the capacity to actually determine whether these things are wholesome or they are unwholesome. I hope you appreciate the complexity of the issue. You are all students of public health care, so I don't need to belabor this. You should be speaking to me. I hope you appreciate the complexity of the issue.
Awesome. Yeah, my Lord. Yes, my Lord.
Good. And do you share the view that our country is really challenging, particularly so when people are not content with their conditions of service and their salaries, and there's the high probability, the high rates that they can be influenced so that the requisite scrutiny which needs to be undertaken before approvals are given out held. You don't think so? Or we have the
it is highly possible that can happen. So that's why you are around the bench or you are sitting on the bench. So that when we pick very vital information like this, then we'll bring it and we'll deal with it and deal with it.
No, so but we don't need it to happen. Because when it happens, you see, before the person is arrested and then prosecuted and probably convicted, the harm will have been committed. So just imagine we have maybe like expired, drugs, and new labels have been put on them, or some other things. You can imagine all the possibilities. And those supposed to do the necessary, testing, verifications, and all that, they don't do the needful, and they just pass those drugs and products to go into the market. You can imagine the harm which will be caused to so many people. Before somebody will do a whistleblowing, and the people involved are arrested, investigated, and prosecuted, people will have been harmed. That is a risk. So,
yes, my Lord, I agree. Yes, so you would have realized that in 2020, when COVID struck, the president of the Ghana Drunkard Association, Moses Draibu, he was...
Did you say what? Drunkards?
Yes, the president of the Ghana Drunkard Association.
They have association?
Yes, they have.
All right.
Yes, so Moses Draibu... Yes, they have. They have. So the president is called Moses Draibu. So he was admonishing his members to tone down on the consumption of the bitter. Because most of the galamsey activities had fell down most of the palm trees. So they were no more going for ethanol in the production of the bitter, but they were substituting it with methanol. Now, methanol, because it is sweet and small quantity, can produce quite a number of the bitters. But the drawback is that it is carcinogenic, so it is cancer causing.
Right.
So in the end, most of his members will die and they will not be alive to drink the bitters. So he came out with a pressure to admonish them to tone down on the bitters and do the peer and the other stuff. Yeah.
All right, thank you. Yeah, so apart from manufacture, importation, distribution, which could be a crime where it is done without the lawful registration authorization, handling, possession, or circulation of counterfeits, falsified or substandard medical products is also criminalized under the Public Health Act. And again, where directives are issued and you don't comply with the directives, that is also an offense under the relevant legislation. So one thing we should appreciate in terms of the distinguishing feature between what we call the general criminal offenses with some relevance to healthcare on one hand, and regulatory health crimes are the following. First, in terms of preventive orientation, we noticed that the regulatory health crimes, their focus is trying to avert a large scale or latent harm. As I indicated, just imagine the various versions of paracetamol. You have so many brands and so on. Assuming a certain brand, which is supposed to be cheaper, comes onto the market, and the Food and Drugs Authority, they don't do like the needful. so many people are going to be affected because that is what a lot of people can afford. So this type of crime seeks to prevent a large scale or latent harm. And proof of actual injury to an identifiable individual is not always required. If we are talking about causing unlawful harm, especially if you are not brought within the permissible justification, it will be necessary to prove that no unlawful harm was actually caused to a particular person or group of people. But then when it comes to regularly held crimes, such as a crime under the Public Health Act and other related special legislation, is not a requirement that you should prove actual injury to identifiable individual before such a crime can be said to have been committed. Number two, regularly held crime are strict or sometimes quasi-strict liability. That is to say that most of the offense, if you are to do close examination, because of the Public Health Act, I'm sure you've engaged the act over and over. But if you were to take the act and do close examination, you notice that a good number of the offenses created under Act 851, that's the Public Health Act, dispense with the need to prove menstrual, like intention or recklessness. And once you commit the prohibited act, for example, you must have registration authorization. You don't have it. You've committed offense. And when it comes to the need to do public health protection, it is very important. And that is why it's a good justification for reducing emphasis on subjective fault, requiring a particular state of mental blameworthiness on the part of the criminal or the suspect. That is not very much important. Again, regulatory high crimes also focuses on the systemic things, the system. So supply chains, for example, institutional practices and market failures, those are the things which are targeted. Institutional practices, for example, you take, let's say that there are certain pharmaceutical companies, certain things that they do, which enable them to probably to produce more quantity, but the potency of certain active ingredients is probably reduced because of a certain technique which they are using to have a certain economies of scale, get more profit. But then the consumer will be the loser. So here, the focus or the target of the regulatory health crime will be like how to address such institutional practice rather than just a particular person or individual. So the bottom line or the takeaway is that with respect to regulatory health crime, it is informed by the conviction that where unsafe medicine, either counterfeit, expired, or not meeting certain approved standards, we have them. It's very dangerous. They can easily spread, and they can cause harm later on, because at the time that they are spread, they are just distributed, you not even appreciate it. So it's invisible at the point of occurrence. When they are doing it, it may look like something so small, so something so benign, but cumulatively, like, as gradually that particular small benign thing is, compiled, it accumulates, it can cause devastating adverse outcome as the case may be. So criminalization in this particular sense is not so much about moral condemnation, like as we may probably see under the general criminal law legislation, but more importantly, as a means of or instrument of regulatory compliance and public health governance in order to safeguard the safety of the public and everyone. Now, when it comes to financial and public health program crime tool, have the potential abuse of a collective healthcare resources. So just imagine we have a national health insurance, which is based upon some kind of a solidarity or principle. We pull state resources and a little contribution by the citizen together so that when we are sick, instead of a one person bearing the full brunt of the costs and expenses, all of us will share it and cover one another. But because of the great selfishness, some people may want to just get money without thinking about implication and the financial sustainability of maybe like the insurance system or a particular funding model. So if we look at the National Health Insurance Act, for example, we also have a crimes which are created. Financial crime within publicly funded healthcare system. And when it comes to submission of claims, if you are to do maybe an undercover investigation, it will surprise you how people actually the same people go in order to generate claims submitted to the National Health National Health Insurance Authority outfits around the country to make claims for money to be released, when in some cases they may not have even earned it, not earned it in the sense that they haven't actually attended to a certain number of patients or certain medications that they claim they have actually administered, as the case may be. These things happen. So these are false or fraudulent claims, and that is also an offense under the Act 852, or dishonest manipulation of diagnosis, procedures, or records to obtain reimbursement. That is also another area. Now, the health professionals among us, you know what I'm talking about. And I'm sure some of you may even know that these things are going on, but you don't have the courage to come out and say it. You have, yes.
The NHI claims you mentioned.
Yes.
Usually what I happen to be an external clinician for NHI. So sometimes go for auditing and see some of these things.
Okay.
But what they usually do is to calculate the entire pay and then submit it back to the facility, then they will deduct it bit by bit. Like they will spread it over a period of time from their subsequent reimbursement from the authority.
Okay.
But as to whether they will hold someone liable or punish, I don't see them doing that. What they do is that they put it together and do the entire calculation, and then you pay in bits. The facility will refund in bits. That is what they do. I don't know if that as a punishment is enough.
So good.
It still goes on.
Yeah. So under the law, the offenses are there. But you know the usual Kenyan attitude. In charge, instead of making sure that people are made. You look at section 107, for example. I just took my legislation. Let's look at section 107 of Act 852. Section 107. I have many doctors in my class, but when I was sick, I didn't benefit from your services. And doctors, why? So, section 107.
You didn't focus on that facility.
I didn't. All right. All right. So, section 107, 1. An officer of the authority who fails to keep proper books and records in respect of claims for healthcare services. B. Falsifies or aids another person or abets in the falsification of tariffs payable to a healthcare provider. Or C. Obstruct a duly authorized inspector of the authority or any person authorized under this act in the performance of a function under this act, commits an offense and is liable on summary conviction to a fine of not less than 150 penalty units and not more than 2,500 penalty units, or to a term of imprisonment of not less than 12 months and not more than 5 years. So section 107, subsection 2. A member of the National Health Insurance Scheme who defrauds or attempts to defraud the scheme by conniving with a healthcare provider or any other person to make a claim for A, a service which has not been provided, B, a service which the contributor does not need, or which the healthcare provider purports to have provided, C, a medicine prescription which the contributor does not require, or which is more than what the contributor requires, or D, indulges in any other fraudulent or dishonest act in respect of the scheme, commits an offense, and is liable on criminal conviction to a fine of not less than 150 penalty units and not more than 2,500 penalty units, or to a term of imprisonment of not less than 12 months and not more than 5 years, or both. Then subsection 107, subsection 3. A healthcare provider providing services under National Health Insurance Scheme who defrauds or attempts to defraud the scheme by presenting to the authority for payment a claim for A, a service which the healthcare provider has not provided, B, a service which the contributor, in respect of whom the tariff claim is based, does not need, but which the healthcare provider proposes to have provided, or C, medicine prescription which the contributor, in respect of whom the tariff claim is made, does not require, or which is far in excess of what the contributor requires, commits an offense in addition to any other disciplinary measure which the board may adopt, is liable on summary conviction to a fine of not more than 5,000 penalty units, or to a term of imprisonment of not more than 10 years or both. Then 4, a person who is not eligible to enroll as a member of the National Health Insurance Scheme and enrolls in the scheme, commits an offense and is liable on summary conviction to a fine of not less than 100 penalty units and not more than 12,000 penalty units, or a term of not less than 12 months and not more than 5 years or both. So if you look at, for example, the section 107 of the National Health Insurance Act 2012 at 852, I just quoted, there are a number of offenses which are created. But what our friends say, these bad practices are going on. It is up to those who are aware to make sure that the culprits are dealt with under the law. But as she said, if you really made a such claim, they said, oh, just pay it, and then we apply it to our next claim and deduct it.
Hello, my lord.
Yes.
I wanted to make a contribution on that.
This is Sylvanus.
Sylvanus, yes.
Yes.
And then we take a J.
What our colleague talked about, what happens is that sometimes as humans, we make genuine mistakes. For example, a patient comes with malaria, and then while treating the malaria, the patient complained about something else that the doctor treated. But in doing that, forgot to add a second diagnosis, but then gave medication for that treatment. Now, if in the course of vetting the claim, the vetting team is not able to determine that and correct it, and it is sent to the National Health Insurance Authority, they call that a treatment mismatch. So that medicine that was given to the patient without any additional diagnosis is deducted. So I think that is why they don't prefer criminal charges against the person, because it's a genuine mistake. And when they come to the facility sometimes to come and take the folders, they see those in there. But then I also know that there are some people, a case in point is a doctor who operates in Kumasi. I won't mention the hospital's name. He is a doctor that works in a government hospital and have a private hospital on the side. So when he comes to the public facility, all the patients he attends to, he lists them and lists their insurance card numbers and take it to his facility. And then he starts there to input it as if they have come to his facility. And he was doing that and was getting paid for a while. And then they noticed a trend in the submission from the government facility and that of his facility. When the Health Insurance Authority went for inspection and they noticed that this is what he was doing, he was arrested because that was clear criminality. But in terms of the government facilities, I will not go brief for all of them, but those are some of the issues that comes up. Thank you, my lord.
All right, thank you very much for sharing with us. I think the lady, the J, yeah, J wanted to talk.
It's Joanna.
Hey, Joanna,
I wanted to add on the audit part, because I know for a fact that I actually know of certain colleague lawyers of mine who do prosecute on behalf of NHI. But one of the quality considerations, if I should say, for the NHI is that at the end of the day, the reality is that we don't have enough facilities that are willing to receive the health insurance card and then issue medication. And so, as much as they do sanction it and then impose fines to some of the facilities and all that, sometimes they also allow the considerations of access to health. Because if they are going to blacklist institutions, at the end of the month, they went up blacklisting more than 50% of institutions, and in certain places, those are the only facilities they have available. Because I'm aware that sometimes when you go to some of the facilities, some of the medication that they say are not on the NHI list, it's not actually true. And if at the end of the day, the NHI is going to sanction everybody, some people may not have access at all. So I know that for some of the institutions, they actually do impose the sanctions, and then where they have to take very extreme measures, they do. Just that it's not always very public, and then they also weigh it with access to health. That's what I wanted to add.
Oh, thank you, Joanna. Yes, so
My lord.
yes.
My lord.
Yes.
Respectfully, on the last page, just of mark.
Okay.
I'll find it difficult to side with the regulator if it is refusing to apply the sanctions because of the considerations my sister enumerated. Because I think the main problem is about funding. The way the facilities are not accepting anything to enroll because of the payment. No, the bills keep long. So if we can do something about the payment, we need to crack the whip, because these limited funds are the same funds that are being stolen. And when we need to apply sanctions, these considerations come in. It's the typical Ghanaian farmer syndrome. It won't work. We need to crack the whip. If you enroll, abide by the rules. If you are the only person living there, abide by the rules. If we are paying them regularly, I believe people will see that even as a source of funding for their facilities and quickly jump onto it. Thank you.
Thank you. So the policy or the normative rationale for offences created by, let's say, the National Health Insurance Act, for example, as we look at Section 107, of course, primarily to prevent the financial loss to the state. But equally important is the need to avoid depletion of limited healthcare resources. Note that healthcare resources are very finite, very limited. We don't have enough. So why should we allow people to even to abuse it and steal it? And also to avoid distortion of service delivery priorities. Look at the concerns that some of your colleagues have expressed. Because claims are not paid, ultimately, it's going to affect users that may need to be treated, and they may turn away or informally may get what is the so-called the cash and carry coming back. Not until you pay. They're not going to attend to you as it will, because we've not been paid by the by the state for the insurance. And we need to be able to buy our drugs and other reagents for our laboratory and so on and so forth. Again, the offenses which are created here are also meant to avoid erosion of public confidence in collective health financing. Undoubtedly, health insurance, especially having the national one, is very important based upon the solidarity principle and so on. But where it is not working, people will lose confidence in it and will say that the system is not working. So we are probably back to what used to be the case in the 90s, what they call the cash and carry system. And of course, it only seeks to prevent indirect harm to patients whose access to care is compromised by fraudulent practices. You can just relate it, where people are doing fraudulent practices, making false claims and all that. Is going to affect genuine patients who are treated, but they have been entered in the records of having been treated when they've not actually been treated, when they actually fall sick. Just because some people are greedy and selfish, they just want to make money, make claims, even where they haven't earned it. So therefore, general criminal law focuses on individual wrongdoing, but public health regulation focuses on safety and risk. And for that matter, it seeks to address institutional integrity and also distributive justice within healthcare. So I'm going to draw the curtain down here, but what is left, I have discussed them broadly. All that I have is just to give like the specifics like of the notes. So I'll draw the curtain here, and then I will send all the materials to you. Read. and use the time to also prepare for your the seminar, which is upcoming, and then we meet tomorrow to continue.
Yeah, my lord, please, I would like to add